Based on your experience, what exactly is a child representative?
So a child's representative is actually a lawyer that's appointed to be the lawyer for the child.
My name is Katie VanDeusen. I'm the managing partner at Sterling Hughes, and today I have senior partner Allie Isroff with me. Thanks so much for joining me, Allie.
Thanks for having me.
So, today on our podcast, we're going to be talking about the differences between guardian ad litems and child representatives, and really kind of giving additional detail as to the differences between each one of these roles and how they are strategically very important in any case, whether it's divorce or paternity or post judgment. So, Allie, let me ask you, just generally speaking, what exactly is a guardian ad litem?
A guardian ad litem is a person that is appointed by the court to come in and help the court determine what is in the child's best interest. So they'll investigate whatever allegations either party is making about the other or about the child and what the child needs. They'll meet the child, they'll meet the parents, and they'll investigate and eventually give a recommendation to the court about what is in the child's best interest. So they're like the boots on
Okay.
the ground for the court.
Yeah, kind of like the court's eyes and ears, and they're really playing a role when it comes to like investigation, right?
Yes. Yes.
Okay. And then contrast that with a child representative. Based on your experience, what exactly is a child representative?
So a child's representative is actually a lawyer that's appointed to be the lawyer for the child. And what I think maybe the biggest difference is actually that the child's representative has confidentiality, like attorney-to-client privilege with the child, and is appointed for that specific purpose. And usually, the child's representative is appointed in situations where the child is older versus when they are younger, and then more often than not, it's a guardian ad litem. But they have similar roles. The child's representative, due to the privilege that they have, is not going to be able to be called as a witness and won't participate in the same exact way as a guardian ad litem. But both are there to represent the best interest of the child and to represent, the child, be the eyes and ears for the court into what's going on with the child specifically.
Okay. And then would you say that a child representative, they're acting as an attorney for the child. Is there some level of advocacy that comes into play with a child representative on behalf of the child?
Yeah. So the child's representative can advocate for the child, but it's different than the guardian ad litem because they're not necessarily going to be able to be called as a witness in court, as I said, because there's the privilege issue. But they can argue for the child in sort of the same way, but they cannot be
Okay.
cross-examined in that because of that attorney role that they're playing.
Got it. And so, one thing that we could note for people is that in practice, a child representative is almost like an advocate, can even negotiate on a
Yes.
child's behalf and engage in settlement conferences to try to resolve a matter. Whereas that guardian ad litem is more of the court's expert and really a tool to use in maybe some more litigious cases where the guardian can talk directly to the judge and say, hey, based on my investigation, I'm recommending this, this, and this.
Yes.
Do you feel like, in terms of calling a guardian ad litem as a witness, in your experience, have you ever taken a deposition where you are actually asking the guardian ad litem questions or maybe even pressing them on their investigation? And how has that played out in terms of your practice?
That's such a good question. I think that typically you would call a guardian ad litem to testify at a deposition to lock in what their recommendations are going to be so that they can't flip flop when they get before the judge. So you're locking them in, which I think is really effective and strategic. I think also in a situation maybe where you're having a hard time with a guardian ad litem and you don't believe that their investigation has been thorough, you can call them and get that testimony out at a deposition so that when they're in front of the judge and they're making these high level recommendations about what is in a child's best interest, you can say, well, look, judge, during the deposition, they testified that they didn't even, meet with any of our witnesses, or they didn't talk to the child's school, or they only met with the child once. This case has been going on a year. So things that they may not, want to testify to, or may sort of try to fudge in a trial, you're going to get that testimony out at a deposition. I think that's really effective. I think it also could be effective to get them to start working harder when they know that you're going to be pressing them on those issues. Then they might say, "Oh crap, this is going to come up in front of the judge. It's going to make me look bad. I better actually start investigating this a little bit more thoroughly."
Definitely. I feel like you can use it to your advantage by really applying pressure to the guardian ad litem. If, exactly as you described, if you're feeling like maybe they are not doing what they need to thoroughly investigate the issues and you want to apply pressure, or to lock them into exactly what their recommendations are and what they're going to say.
Yeah.
Um,
Because I feel like all
let
of us
me
have been
ask
in the
you,
situation where, like, we'll talk to a guardian ad litem, they'll tell us what they're thinking, and it's very pro our client, and maybe that's because they're talking to us, and then they talk to the other side, and then they come back, and it's like all of a sudden something's changed completely, and you're like, well, wait a minute, like, what changed between now and then? So I think it's a really effective tool to lock them in.
Yep, I totally agree with you. In terms of your practice, do you usually see a guardian ad litem producing some type of report? And how do you use that in a litigious case?
I think that they will always put together a report, whether it's oral or written, for the judge, and either give it, as I said, orally, or produce it as a written report. Producing it as a written report tends to cost more money, so sometimes they'll ask the lawyers whether they prefer just to give the oral, whether we prefer as lawyers for them to give an oral report to the court. Um, in most situations, that's completely sufficient. You're going to have a court reporter potentially anyway, and be able to get that record. But yes, they will produce a report, and then you can potentially look into their investigation, how thorough they completed an investigation, what they actually did, where the holes are if you need to find holes, or where you could bolster some of the points that they've raised. As if they have concerns about the other parent, maybe that's something you're going to dig into further, with discovery or with further investigation of your own. So certainly it can be used a lot of different ways in order to help your client's case. And I think one thing that we've talked about before is, when you get these reports and maybe you feel like there hasn't been enough investigation, or maybe you're getting the report and you're learning that, wow, they're really not going to be recommending a parenting plan or a parenting a decision making, or a parenting, for parenting time. They're not going to be making a recommendation in your client's favor. Then you have a choice of what to do, because in most cases, you're not going to be able to file a motion and get rid of the guardian ad litem. The judge isn't going to allow that. So then makes you think about what next steps are. Um,
So going directly to that point, I feel like as attorneys, we always have clients asking us, well, how likely is it that the judge is going to remove this guardian ad litem? Or I want a new guardian ad litem. How likely is that to happen, or how unlikely is that to
It is
happen?
highly unlikely. In fact, I've actually never had that happen. The the
Same.
only time I've had and oftentimes even in a post judgment case, so your case is resolved, you've been uh, abiding by the allocation judgment or the parenting plan that's in place, and then something comes up and you're back in court, and the court's going to likely reappoint that same person. So unless there's a really big reason, or a big bias that you were able to uncover, or that you sensed during the first case, or even in the beginning, like if you're not in that post judgment situation in the beginning of the case, the courts are very unlikely to tell a guardian ad litem that they're being removed, mostly because they feel like that will upset the rapport that that person has made with the child, and the courts are most concerned with the child. They are less concerned with the parties, even though they're the ones paying for everything and being a part of everything. They're most concerned with preserving the relationship that this person may have built with the child, and then upending that, and then having to bring somebody else in, because that could be really awful for the child, and so they're trying to protect that. So in that way, I guess it makes sense, and I can digest that. But it can be very frustrating when you sense that there's a huge bias one way.
Absolutely. I feel like in my experience, even if you want to go the route strategically of asking the court to remove this particular individual because maybe you don't think they're doing a thorough enough job, or maybe you disagree with the positions they're taking, the risk that occurs there is you're filing a motion to remove them, and the judge denies you, and then you're still stuck with that same individual investigating that case, and you've almost alienated them even further.
Exactly.
So it's so hard in those circumstances to kind of navigate that and to especially explain that to a client. Let me ask you this. In a circumstance, Allie, where a guardian ad litem is making a recommendation, or maybe even a child rep is taking a position in settlement on behalf of their client that you disagree with, you really don't believe is in the children or the child's best interest, what is your next step? What other professionals can you kind of lean on strategically in a case to help your client, because they really truly believe that maybe these individuals have gotten it wrong?
So I think that there's a number of different things that you can do, and it really depends. And I think that's where like the attorney comes in. It becomes really important that you trust your lawyer, because if you trust your lawyer, they're going to tell you what the options are, and part of those options are taking into account the cost. Sometimes the best option is getting something called a 60410B evaluation, where you're hiring a professional to come in and really dig into all of the factors that are relevant to parenting time and decision making. And they will, the fee for somebody to do something like that is somewhere between like $10,000 and $20,000. So there's a very, very large cost associated with it, and sometimes they're going to come back the same way. So you have to, discuss that with your client, explain the risks and the rewards of that and the cost, and make sure they really want to do that. I think, oftentimes another approach could be asking your client, well, are any of you guys in therapy? Like, what about if we get you guys in therapy? Because then maybe what you're doing is you're making a more cost effective, you're taking a more cost effective approach. Everyone's getting help. Mental health is great. And then this
Yep.
is another witness that the guardian ad litem can then speak to, that will have a
Yep.
more personal relationship with everyone involved. And it won't be this one biased person that, or if that's the way you feel, this one person's opinion. Now you've got at least another expert there.
Yep. Some other professional that maybe is coming in to shed additional light on the situation, or to even make the guardian ad litem or the child rep maybe see things a little bit differently.
Yes.
So those are great suggestions. Family therapy, individual therapy, that 60410 expert. Speaking of cost, though, Allie, given your experience, have you ever had a case, or I guess my bigger question is, how do courts address cost for these individuals? Specifically, let's talk about a guardian ad litem or a child rep. How does the judge decide who pays for what?
So in I'd say very rare situations, the court can appoint a guardian, a court-appointed guardian, which is through Cook County. Well, I think Cook County. I don't know if every other county has that, but in Cook County they have uh, the guardian's office, and they can appoint somebody there, and that's usually much more low cost. But other than that, usually the cost is, I would say the majority of the time, the courts allocate those costs 50-50. But what they will say is it's subject to reallocation, meaning that
Okay.
at a later date, the courts can reassess what that allocation should be. If the parties are, if the parties earn the same amount, or maybe maybe they earn differently, but one party has a significant non-marital estate that could help them, to be able to afford um, these extra resources, then the courts generally will go 50-50, subject to reallocation, and then potentially reallocate those costs later on. But your lawyer, if you're the lower wage earner, should always be asking for a lower allocation. So 60-40 or 70-30 for the payment of the guardian ad litem. Or
In your practice, have you ever experienced a situation where a judge maybe made an initial determination as to how that expert should be paid, or how that individual should be paid, and then changed their mind or reallocated those fees at a later date?
yes. So all you have to do is file. I mean, if you feel like it was not done in the best interest of your client, maybe it was 50-50, but like your client earns 20 grand and the other party earns 200 grand, and it was 50-50. Obviously, that's a situation where I think it warrants filing a motion to reallocate those fees. And typically, if you were involved in the case, at the get-go and that person was appointed, you put it in the order that it said subject to reallocation. So the court has the ability to reallocate later on.
Definitely. And then any other, kind of tidbits from practice or any really, let's say, stories that are standing out in your mind when it comes to a guardian ad litem or a child rep that you'd like to share today?
I think that the best takeaway I have is that it's really important, again, to trust the lawyer that you have. And a good lawyer is going to always try to put your and his or her best foot forward with that guardian ad litem, and is going to be thinking through constantly how to make you or the situation look better on your behalf. And I feel like just recently we had a situation where, I'm talking to a guardian ad litem. It seemed like he had had a bad day earlier in the day, and became a little frustrated during our call, where he had been completely like blown away by me in our first interaction. And
Yep.
so, I reached out to some other colleagues at our firm to discuss, like, how do I handle this? What are the next steps I should take? Should I, apologize? Should I, send additional information? And I think it's really important, that you always stand behind your clients, the position that they need you to put forth and argue for, but be respectful, and always try to, you know, we're all human. And everyone's going to have bad moments and good moments. And hopefully what you can do is, if things, turn a little bit in a way that's not necessarily in your favor, that you have a lawyer that is, self-aware enough, and has the sort of training, I guess, and expertise to try to, resolve that and make it a better situation. Because
Yep.
they're lawyers, they're humans, they're gonna have their days, we're gonna have our days. And I think it's really important, though, to have somebody who's respectful, professional, and always thinking about you and your best interest at the end of the day.
Absolutely. I could not have said it better myself. Allie, so this ends our podcast today. And I just appreciate you so much for joining us to talk about guardian ad litems or child reps, and also sharing some strategic insights as to what to do with each. And it's just amazing to have you. So thanks for joining me.
Thank you for having me.
Guardian ad litems and child representatives can make or break your custody case in Illinois. But most fathers think that just being on the birth certificate gives them automatic rights. Wrong. You could lose access to your child overnight. And here's the one thing you must do to protect yourself that nobody tells you about. See what catches fathers off guard in our next video.